for an email newsletter, we generate private, sensitive data. Companies have been free to buy and sell that data without any permission from us, without our knowledge even, and without any mechanism for us to make them stop. On July 31st, coming up in just a few days, that all changes in the state of Minnesota, when the Minnesota Data Privacy Act takes effect. The law gives Minnesotans more control over data. Young people in our state have a special protections to make sure that their data is safe. Businesses that collect online data will have new obligations around transparency and security. And put together, all of this will make Minnesota a much safer, more secure environment for consumers. So how much data are we talking about? Quite a bit. If you feel like every interaction you have, online or otherwise, is being tracked or recorded, then you're not far off. The messages we send, the purchases that we make, and the apps that we use, where we use them, when we use them, the time of day that we use them, all of those things create the data that is being monitored and stored to build private profiles of all of us. Each individual data point may not seem like much, but when you add it all up, it's really staggering. The average person generates about 1.7 gigabytes of data daily. That's the equivalent of taking 2,000 pictures with your phone every day. That's a lot of data. And our inability to control where it goes, how it's used, who gets paid for it, who gets to invade our privacy, is a big deal. It's even a threat to our safety, particularly with anyone with bad intentions can access your name and your home address with just a small online purchase. The Minnesota Data Practices Act gives us new protections and more control over our personal data, including your name, address, email credentials, and your browsing history. The law also creates stronger protections for our sensitive data, a category that includes private information such as ethnicity, race, religion, mental or physical health, sexuality, specific location, as well as genetic and biometric information. Now, there are a lot of new rights for consumers in this bill, thanks to Representative Elkins and all of those in the legislature. So to keep track of all of the new rights, we come up with this little acronym, LOT Plus. So if you look up here, this is a nice way of understanding what people get. L, consumers can get a list of third parties where your data was sold. O, you can now opt out or say no to businesses selling, profiling, and using targeted advertising with your personal data. C, you have the right to a copy of the personal and sensitive data in a business has about you. K, you have the right to know what personal information has been collected about you. E, you can now edit any inaccuracies in your data. And D, you can ask a business to delete personal and sensitive data they collected about you. I'll get to the plus in a minute. So that's locked. So, why the plus? Well, the plus is because Minnesota's law has a lot of what the other laws have in other states, plus extra protection. That's the plus. Businesses must get permission from a parent or guardian selling the personal data of consumers under 16 or using their data for targeted advertising. Kids under 13 have even stronger protections. Consumers can question the results of automated decisions made about them so their data can't be used by AI or other tools to deny them access to housing, education, employment, and other essential services. And businesses must have a privacy notice with the contact information and a process for Minnesotans to exercise their locked rights. And they have 45 days to respond. Our office is ready to get to work alongside Minnesotans to enforce these new rules. We've launched privacym.com, privacymn.com, a website with more information on consumers' Locked Plus rights. It includes draft letters consumers can use to exercise their rights, guidance on how to report violations, tips on how to set up a universal opt-out mechanism, and more. And we're hiring people to make sure it all happens. We are hiring new attorneys and investigators to look into the violations of law to take action when those violations occur. And we ask every consumer, we ask everyone, if you believe that your Locked Plus rights are being violated, or if you have any issues exercising your Locked Plus rights, don't hesitate to file a complaint with our office. And you can call us at 651-296-3353 or go to ag.state.mn.us. So again, I'm very grateful to everyone who helped make this law a reality. Thankful to the legislators, of course, leader being Representative Elkins, but I'm also thankful to businesses who came forward and gave good advice, and thankful to people who testified, including people in my office who did that. Special thanks for them. And I just want to say that we cannot and should not just think that violations and invasions of our privacy are just the way it is in this modern time. We have a right to our privacy and we have to protect it. And this Steve Elkins bill is a big step forward, and we're honored to be able to work with Representative Elkins to make sure not that we just have a good law, but that that law is enforced. So with that, let me introduce Representative Steve Elkins.
Thank you.
Yeah.
Yeah, so I took on this project during my freshman year in 2019 when Amos Briggs, a local lobbyist for Microsoft, came to visit me with a model data privacy bill. He'd been looking for an author, and everyone in the legislature told him, yeah, go talk to Elkins, he's our data geek. So I'd spent the last 25 years of my career in information architecture, basically managing data, and so I told Amos, look, I can't guarantee you I'm going to try and get this particular bill across the finish line, but I agree with you that I'm probably the right person to pick up this topic. And so at the very end of the 2019 session, in the waning days of the legislature in May, I dropped the bill, and within days I was besieged by every tech lobbyist under the sun from around the country. And eventually ended up for this bill with a stakeholder notification list that had 128 different emails in it. So nobody can claim that they weren't heard in the drafting of the bill. So during the bill process itself, the bill was amended 5 times, but every single amendment was an author's amendment, which means that I wrote it myself based on the feedback I was getting from stakeholders, and it was a very broad group of stakeholders. And so among the people who I had regularly vetting the bill were representatives of technical business groups like TechNet, or the State Privacy and Security Coalition, or the State Chamber of Commerce on the one hand, but on the other hand, I was also taking feedback and having the drafts of the bill vetted by Consumer Reports, the Electronic Frontier Foundation, the Electronic Privacy Information Center, and the ACLU. So I was taking feedback on this bill from all quarters. And I didn't learn about this until later, but the bill was actually the first draft of what's called the Washington Privacy Act. And the Washington Privacy Act was drafted by a now retired, Washington State Senator named Reuben Carlisle, who was looking to adopt something like the recently adopted California Consumer Privacy Act, but read the CCPA and said, oh my God, this is awful. An opinion which, by the way, is shared by the California legislators who drafted the bill. They had all of 2 weeks to draft it. So he and his staff basically took the CCPA apart and rewrote it from scratch so that it was better organized and more legible. And the tech community, was like, okay, this is going to come one way or the other. We can do it the California way, or we can do it the Washington way. We think we like the Washington way better, which is how I came to have possession of that first draft of that bill. So Senator Carlisle updated his bill draft 2 years later when the California voters adopted the California Privacy Rights Act. And that was a much better bill as a starting point. Virginia, then Colorado, then Connecticut picked it up, but each iteration it got a little bit better. So the second draft of the Minnesota Consumer Data Privacy Act was based on the Colorado and Connecticut versions of the bill, which had been very well vetted in advance. And since we were the last state, the 19th state so far to pass this bill, and no states have passed one since then, I also had the opportunity to take advantage of all of the improvements that were made to the basic bill framework along the way. I took a better definition of small business from the Texas bill, improved the language related to exemptions for financial services data from Oregon, the requirement that companies provide you a list of everyone they've sold your data came from Oregon and in Delaware. And then we added a few unique provisions of our own, mostly based on my 25 years of experience in managing data. We adopted what I think is a more enforceable definition of what constitutes precise location, an explicit prohibition, which was only implicit in other laws. It says you can't take data that was collected anonymously and try and identify the person that it relates to. I put in explicit requirements that companies in their annual assessment describe their policies that limit the data that they collect about you to only that data which they need to do business with you. Their policies related to disposing of the data once they have no further use of it to do business with you. And a requirement that data actually keep a catalog of the data they have so that if you ask them, for example, to delete your data, they actually know where to find it. And probably the most important innovation that other states are starting to copy is a provision that gives consumers the right, based upon the rights we already enjoy under the Fair Credit Reporting Act federally, to be able to question any profiling of our data, basically automated decision making that gives us a score, like our credit score, which is the epitome of them. And it gives people the right to look at the data that was used to score them, correct any errors in the data if it's wrong, have the model rerun with the corrected data, and to just have a basic, plain English definition of, why did the model produce the decision that it did. So if I go into my credit data, and I've done this, at one point I noticed that my TransUnion score was lower than my score with the other credit rating agencies. When I looked at the data, I saw that they had a credit report for a home improvement loan that I paid off 2 years earlier, still on my record. So I reached out to them. I said, hey, look at this one. This one's long since paid off. They corrected it. The next time I looked, the credit score was in line with the other credit rating agencies. So now you will have, under the Minnesota Consumer Data Privacy Act, the right to do the same thing, whether it's with respect to apartment or employment, education. I have a friend who actually turns out to be a data privacy lawyer, very knowledgeable about this stuff. He applied for an apartment last year, and the guy is a pillar of the community, probably earns a couple $100,000 a year, and they turned him down. They wouldn't give him access to any of the apartments in this brokerage's network. And when he asked them why, they just said, it's proprietary. Well, that's not acceptable. If a consumer is going to be turned down for an apartment or a job based on some algorithm, they should have the right to have an ability to question the results of that and be told, in plain English, why that came out the way it did. So, as a result of all of this, the fact that we're based on a common framework used in 18 of the 19 states that have passed these laws, the Future of Privacy Forum, a watchdog over this stuff, said that ours is among the strongest consumer data privacy laws in the country at this point. I'm very proud of that. And to the critics who might say that we're fostering a patchwork of state laws, isn't this really something that Congress should take on? I certainly agree that This is something that Congress should take on. They had a false start last year with a very good bill draft that would have been worth adopting, and the day before it was to be marked up in the House to be amended. Mike Johnson just put the kibosh on the whole thing. So in this case, states are acting in their role as laboratories of democracy, and I hope that when Congress does act, that they will take lesson from the work that we've been doing in the various states. I would say that, because 18 of the 19 laws are based on the same basic framework with the same definitions, the same basic rights, we're already seeing that attorney generals across the states are already cooperating with each other in the enforcement of these laws. So we're not going to be out there hanging out by ourselves, wandering in the wilderness. And in fact, this coming Sunday, I'll be at the National Conference of State Legislatures. Sunday, the task force on data privacy and artificial intelligence will be meeting. I'll be meeting with my colleagues from these other states because the work that we're doing to both conform our laws across states and improve upon them is ongoing. So with that, I think we are ready to take questions.
Attorney General Ellison, how much is this going to cost your office additionally? And so you're hiring more people, and
Yeah.
I mean, do you expect the public will have a lot of interest in this, and I think I get you over the mic?
Oh, yeah.
Thanks.
Let me tell you, people are interested in issues of data all the time. In our office, we have handled like several major data breach cases. How many would you say, Jason?
Probably half a dozen.
Half a dozen. People care about this stuff. They want to know what's happening with their data. The question is, do they have a place to go? Is somebody going to enforce it? The thing is, history tells us that you can write a great law, and Steve did. But if you want that law to really mean something, you got to have some people to enforce it. So what's the dollar figure? I don't know, the legislature gave us some money for it. What was the?
I think it's about 200,000.
About $200,000. Yeah.
And how many more people are you hiring to work?
I think we're gonna hire like 3 lawyers and an investigator.
Thank you.
Representative Hopkins, could you speak to what kinds of businesses this will most commonly affect?
Yeah, I think that a lot of the attention will be this class of businesses referred to as data brokers that buy and sell data. I'll give you one very pertinent example right now is that in the wake of the assassination of Speaker Merida Hortman and her husband and the shooting Senator Hoffman and his wife, all 201 state legislators have been given subscriptions to a data deletion service. There are about a dozen of these kinds of data deletion services out there that provide a service of going out to all of the data brokers. So instead of having to go to each individual data broker individually to exercise your right to have your data deleted, you can go to one of these services. They know who all the brokers are, and so they submit these deletion requests on our behalf. So data deletion requests have been submitted to all of the data brokers who collect and then expose all of the services that you saw that Vance Belter had listed of this is where I'm going to look up legislators' addresses. All of those are on that list. So we'll be checking. We get reports. We can see which sites have deleted our data and which ones haven't. And we look at that as low-hanging fruit for us for enforcement. And especially since we're kind of a sympathetic audience right now. But that's one avenue that we intend to pursue is just looking at data brokers and seeing which ones have acted on our right to have our data deleted and which ones haven't. One of the other ones that I'm kind of interested in is that I used digital advertising in my campaign for the first time in 2023. And so before I signed up for the service, I asked the company that does the places the advertising, was like, how do I know that my ads are going to reach the voters I want to reach? And he said, well, it's simple. I have a partner who has mapped just about all of the devices in the United States to the places where they spend the night. So you send us a list of the voters you want to reach and their addresses, and we send your ads to all of the devices that live at those addresses. So it kind of begs the question, how did they get that mapping of devices to addresses? And I think one of the major sources actually is like the free weather apps we all have on our phone. So there's an adage in the software industry is that if you're not paying anything for the product, you are the product. So the first thing you do when you get up in the morning is check your weather app to see what the weather's like so you know how to dress. That weather app has collected your home address. And my favorite weather app is one called My Radar. I was on it for about 2 hours last night. But they were so audacious as to when Apple upgraded its location privacy controls on iPhones. I set my location preference for My Radar to only when using and don't reveal my precise location. And within minutes, I got a message from My Radar saying, don't do that, that's an important part of our business model. And My Radar is now going public, and so I looked up their SEC documents and discovered that they make over $400,000 a year from selling data. So that's another avenue that I think we'll be pursuing. So there's a lot of low-hanging fruit out there, and we're really hoping that that consumers will use the Attorney General's website and submit additional leads to us ourselves. We'll be going back to my friend who didn't get the apartment to see if he's willing to submit his request again as well.
We'll be looking for it.
Yeah.
Representative Elkins, first, also a My Radar user, was on it all last night.
Yeah.
Good to know that. But I have a question just about how the internet or social media is going to look for people once this takes effect. It's like, what do you think the experience is going to be like when you're going through your feed or browsing different websites? Do you think there will be any market change that people might notice in how ads are working and targeting them?
Yeah, there's a right to universal to opt out, so you can say I don't want my data used for targeted advertising. The industry's been kind of slow to implement that. So in DuckDuckGo and Mozilla Firefox, you can do a setting that just says, I don't care who you are when you're using our browser, you can't track the consumer. So as Chrome and Bing also adopt that universal opt-out mechanism, that will make a big difference. So Colorado's kind of been taking the lead in the development of the universal opt-out mechanism. And so most of us who have passed laws since Colorado have kind of a Me Too clause in there, basically that in effect says, when Colorado gets all this figured out, this will apply to us as well. But companies like Google, Google in particular, and Amazon are pretty much self-sufficient for their own data. They claim they don't sell it. They don't really need to. They can collect everything they need internally. But I know that Google buys data, and in fact, there have been some notable breaches involving their Google Analytics. There was a really famous case a couple of years ago where there's an app called Flow that women use to track their menstrual cycles. They contracted with Google Analytics to analyze their web data, but part of the deal was that Google Analytics got to keep a copy of their data, which was a gross violation of their published data privacy policy, and the FTC came down really hard on them. So I think you'll see. I think the progress is probably going to be gradual, but now that we can also leverage tools like these data deletion tools. The tools that the consumers have at their disposal are going to get better and better. Consumer Reports has a really good analysis that they did of the data deletion services a month or two ago. It's worth looking up on their website. It was really well done. And then there are all kinds of data privacy watchdog organizations that we're working with as well.
So if people, I'm sort of overwhelmed by this.
Yeah.
I can imagine a lot of people are overwhelmed, don't even know what the hell
Yeah.
they're collecting. I mean, is privacymin.com a place you can go? Is that like And where would people start to start?
Well, they would click on the website, and then they could read about all the things that it provides and how to get to those things. So if you wanted to use it, it's blocked out, it would say, go here, go here, go there. And so it's sort of like kind of a menu, recipe book, walk you through kind of thing.
The privacymin.com thing is?
Yes,
Okay.
yes, and so it's right here, thanks for, I hope you guys advertise that website. And share our number, because all the people who answer phones for us can direct people to the same place.
On the compliance, do you know, I mean, if any businesses in the past, when other states have taken this up, have been more difficult to find compliance with? Or, and also just, how are they preparing and what do they ask you guys for in getting ready to comply with the law?
In my experience, most businesses comply when the law comes down. They have people watching them, what the law legislature is doing, and they do comply. Some don't. That's where we come in. And, we're here to enforce the law. So I would say that if you're a business and you want to know how to comply with the law, you can go to the website, you can call my office, and we'd be more than happy to share the information with you, because we really don't want a lawsuit. We want compliance. So this is, and by the way, fun fact, it was an industry person who came to Steve in the beginning with the idea. So not everybody in the industry is trying to ravenously gobble up everyone's data. But we got kind of a wild, wild west out there, and so this law provides real good stuff. But how will we enforce it? If we get violators and reports, we'll follow up, we'll investigate, and then we'll hold people accountable. We anticipate most will follow the laws. We know some will not.
Do you guys list on the website, like, some of the services that you can pay, as examples of services that are being offered from legitimate companies or anything? Or is there any advice you give consumers on using those private companies to kind of do all the work for you?
Steve, you can take that one, or I can ask Caitlin Miko, who did a lot of work with Steve on the bill.
Thanks.
Caitlin, go for it.
Hi there. We don't specifically endorse any specific service, but we certainly do try to give consumers tools for them to exercise their rights, and strongly encourage consumers to contact our office for additional information. It's also going to be part of our ongoing efforts to continue to do consumer outreach, because we definitely appreciate this is a big area with lots to learn. And we're hoping consumers will take it in small bites, start to implement it in their daily use, and that will be able to be helpful along the way.
And I'll just say, if you click up the website, it'll take you right here, and then there's some icons you can press. Information for consumers, that will be in the purple. Information for businesses, that will be to your question around business compliance. And then frequently asked questions, and under there, does the Minnesota Consumer Data Privacy Act apply to me? It'll tell you, how can I exercise my rights? It'll tell you, how can I complain about a company not respecting my rights? It'll share that out, so it kind of walks you through it.
Well, is this a game that we can win though? I mean, it just feels like they just keep adapting and it's like drinking from a fire hose or something. What's the point?
It's a great question, but it's a game we better try to win. Because if ever we put our hands down, we're gonna be so far behind once things get really bad, that we might not be able to catch up. So we better do the best we can with what we got now, so that we can at least keep pace and match, as opposed to just throw our hands up. And that's the worry that I have, that people might just throw their hands up.
Yeah, no, I mean, the Texas Attorney General's office has already, won a major enforcement action against GM, and they're going after other auto manufacturers as well. It was like a $25 million fine for selling driver behavior data to insurance companies and insurance data profilers, basically. And I think that's going to be an example. The big change, I think, is that now that more states have passed these laws, is states' attorney general teaming up on joint enforcement actions and stuff like this. The other thing I will say is that in terms of business acceptance, what I've generally found is what I would call the platform vendors, the Apples, the IBMs, the Microsoft are generally in favor of this stuff. They see the need and they're not doing a lot of data brokering themselves. Most resistance will come from the data broker industry and the online advertising industry. A couple of states now, Oregon and Vermont and California, have created registries for data brokers, and we've got a bill being drafted right now that would copy the Oregon, Vermont bill so that we would have like one-stop shopping for a list of data brokers that are subject to our law, which will make it a lot easier. The deletion service that we're using already maintains a very long list that is accessible to us right now as subscribers to their service. And any consumer who has access to consumer reports, they're doing some really good work to provide information for consumers on how best to pursue these kinds of rights. EPIC is an organization, the Electronic Frontier Foundation is an organization, are also providing really good consumer resources. So I don't, given that, you know, data brokers are an identifiable class, data profilers are kind of an identifiable class that I think we can catalog. I don't think that it's hopeless at all.
Representative Elkins, could you speak to any exemptions under the law, both in terms of entities and businesses, and then consumers, like are any public officials, lawmakers, for some reason not?
So, so health data has long been governed by HIPAA and high-tech. So HIPAA provides a baseline, unlike some other data privacy laws. So in Minnesota, we also have the Minnesota Health Records law as an overlay. That law is in desperate need of a modernization. And one of my current projects is to take the Minnesota Health Records Act, modernize it, and fold it into the Minnesota Consumer Data Privacy Act. I have a bill out there already that's modeled after another Washington bill called My Data, My Health, that would bring data from like our apps, health apps, or health or wearable devices under the definition of sensitive personal data, which means sensitive data is classified as sensitive. A company can't sell it without your advance permission. What else do we have? So Minnesota already has a version of Daniel's Law that makes the data of judicial officials private and hides all of their data. Representative Bonner is working on a bill to extend that protection to legislators and other public officials as well. So there's still work that we'll be doing, and that's one of the reasons why this multi-state group of legislators continues to regularly convene and meet and exchange notes about how we can better improve all of our bills and keep them in conformance. The financial data, financial data is already covered by the federal Gramm-Leach-Bliley Act, and so in our bill, some states, the early states, just completely blanketed any financial organization that's governed by Gramm-Leach-Bliley from their state laws entirely. And ours, we followed Oregon's lead and said, your data is exempt to the extent that it is either covered by Gramm-Leach-Bliley or is protected as if it were, so that it has equivalent protections.
What you can tell us about scope? I know that there's carve out for small businesses and stuff, but just like, for the average person who's thinking about who's gonna have to answer to my request, is there more that you can tell us?
So that we adopted the approach taken by Texas and Nebraska. Originated in Texas, and we took the approach that's preferred by the National Federation of Independent Businesses, the primary trade group for small business. And what that provision says is that you're a small business if you're a small business as defined by the Small Business Administration. And every small business knows whether or not they meet that definition. So there's still a provision in there, as in most other states, that you're a small business if you're below some threshold. I'm probably going to end up taking that out because in general the business community prefers the Texas approach to it. And even under the Texas approach, if you are a data broker in the business of buying, selling, profiling data, that exemption will apply to you even if you are a small business.
Did this have I assume bipartisan support?
Yeah, it went, the bill went through, all of its committees, in the House and the Senate. I think without dissent, I think I had one negative vote in Commerce. And then it got piled into the marijuana omnibus bill, which passed on a party line vote. But going through committees, I had almost unanimous bipartisan support all the way through the process. Representative Niska was assigned to shadow me, and I kept him informed all the way through. And there are a lot of privacy advocates on the GOP side of the aisle as well. Representative Scott has always been a diehard data privacy advocate. I'll be serving on the Legislative Commission on Data Practices this fall, and she's on that committee as well. But in general, this has not been a partisan issue. The Texas version of the bill was, the chief author was Representative Giovanni Capriglione, and Gio, as we call him, got the bill through the, very similar bill to ours, got it through both houses of the Texas legislature with no negative votes. So this is a nonpartisan issue.
Back to the GM example earlier, that the Texas Attorney General took action against, and I believe we sued GM, and FTC also reached an agreement with GM about Spark Driver, or
Yeah, so.
their digital system. I mean,
So
I guess, sorry, but to the heart of my question, are these things happening to Minnesotans and we just don't have the tools to know, or we don't have the tool to take legal action? And does this
Yeah, so-
provide that?
Yeah, so that's the thing. Up until now, Minnesota hasn't had these protections, except that to the extent that they can be prosecuted as basically just fair trade violation. In fact, that's most of the FTC enforcement has just been on basis of deceptive trade practices. But now your location data, your movement data, which is what part of the data that the manufacturers are picking up, would be considered sensitive personal data. And again, sensitive personal data cannot be sold without the consumer's consent. And GM and other manufacturers were selling that data to brokers and profilers without the consumer's informed consent.
Thanks, everybody.
Thank you.
All right.